Welcome to Topic 5.1, Constitutional Protections of Civil Liberties. This is the first lesson of our fifth of 6 units. This one is being called Courts and Your Rights. The goal of this lesson is to be able to describe what your civil liberties are and how the Constitution protects them. As usual, make sure you're following along with the fill-in-the-blank notes and reach out with any questions. The first big question is, what are civil liberties and what are civil rights? These two terms get used interchangeably a lot, but they don't mean the same thing. Civil liberties are the individual rights that we have. They're the natural rights that we've been talking about all semester. Civil rights, on the other hand, are protections for groups of people, such as racial minority groups. So civil liberties are the rights of individuals that we all have that we're born with, whereas civil rights are extra protections the government gives to groups of people who have been abused in the past. Again, the easiest way to differentiate between these two is civil liberties are about individual rights that we all have because we're human, and civil rights are extra protections the government has given to groups of people. So, next question, where do civil liberties and civil rights come from in the first place? In America, we believe that civil liberties are natural rights that we all have because we're human. A religious way of thinking about this is these are the rights that God has granted individuals. But again, not everyone's religious, so it's best to think of these as just the rights we all have because we're equal, because no one human is better than another human. Many of these civil liberties, but not all of them, are listed out in the Constitution and what you may know of as the Bill of Rights. So if you're thinking about freedom of speech, freedom of religion, these are civil liberties, and are the sort of things that Thomas Jefferson was referencing when he said in the Declaration of Independence that we all have a right to our life, our liberty, and pursuit of happiness. Liberty here is referring to civil liberties. Civil rights, on the other hand, aren't things that we all have because we're equals. Civil rights are protections the government's created for groups of people because historically the government has treated certain groups as less than equal. So to make up for the problems of the past, we give extra protections to make sure people aren't discriminating against protected groups. So some of these groups include African Americans, Native Americans, Latin Americans, women, members of the LGBTQ plus community. Throughout the U.S. history, the people in these 5 groups have been a political minority. That is, they didn't have the voting power to protect themselves from the will of the majority, who used their majority voting power to pass laws like segregation, or banning homosexuals from government work, or kicking Native Americans off their land, or denying women the right to vote. Just some examples. Any plain reading of the U.S. history shows that historically, straight white men have controlled the laws of our country, particularly straight white men with property. Laws were written to give this group an advantage by giving them more power over other groups. Civil rights are protections to level the playing field because of the misdeeds done by our government in the past. For example, after the Civil War, African Americans were no longer being enslaved, but they were still being segregated, and many states across the U.S., North and South, were passing laws making it extremely difficult for people of color to vote. So in the 1960s, Congress passed the Voting Rights Act with its legislative power, and the president, with his executive power, signed it into law. This law was authorized under the Equal Protection Clause of the 14th Amendment. It said any state that had a history of passing laws designed to stop people of color from voting or making it more difficult for them to vote could no longer change their laws unless they got approval from Congress first to make sure that those laws were not discriminating against people of color. The Voting Rights Act also required ballots, those things you use to vote, to be printed in multiple languages if the community had a large language minority group. Essentially, the law said if you had a large number of people in a voting ward or voting district that spoke Spanish, you must have ballots available in Spanish. If you have a large group of people who in that voting district who speak Russian, you must also have ballots available in Russian or Polish or Arabic or whatever the language is if there's a large enough minority group to qualify for this law. The idea behind this part of the law is that no one should be denied the right to vote just because they don't speak English. After all, there is no official language of the United States. Around the same time, Congress passed a law known as Title IX. This required schools that receive federal funding to treat boys and girls equally when it came to sports. For instance, this is why we have a boys baseball team and a girls softball team. If there was no girls' softball team available, then the school would have to allow any girl who wanted to play on the boys' baseball team. It's why you're seeing more and more girls going out for football because, well, there is no girls' football team, and Title IX says boys and girls have to be treated equally in schools, and that includes in sports. Now, if you're thinking, you might go, wait a minute, but isn't education part of what the states are responsible for? Isn't this the federal government encroaching on the powers of the states? Isn't this a violation of federalism? Well, first off, good for you for thinking that, but actually no. This is because the federal government is not requiring schools to do this. It just says if you want extra funding from your schools to come from the federal government, you have to comply with this law. If you don't, well, that's fine, but the federal government just won't supply you additional funding for your schools. Remember, most school funding actually comes from local and state taxes, not the federal government. It's just extra money. The Civil Rights Act of 1964, also passed around the same time, banned segregation based on race in all public spaces. Now, before this, in Brown v. Board of Education, segregation was banned in public schools, and that's because the 14th Amendment says governments cannot treat people differently. Schools are run by, or at least public schools, are run by the state, and therefore the state cannot segregate, as then it would be in violation of the 14th Amendment. That's how the federal government was able to desegregate public schools. However, private businesses like restaurants and movie theaters and hotels, well, they're not run by the government, and so the federal government had to find another way to ban segregation in those public spaces. And that's where they passed the Civil Rights Act of 1964 to integrate restaurants and movie theaters and hotels and all that. They used the Commerce Clause to authorize this because they said the food served in a restaurant crosses state lines, and therefore it's interstate trade. Movies shown in movie theaters cross state lines, people who stay at hotels cross state lines, and therefore the federal government can use the Commerce Clause to force these public spaces to end segregation. The Civil Rights Act of 1964 also banned discrimination based on sex, which has been used to justify extra protections for the LGBTQ+ community. This expansion of the Civil Rights Act of 1964 to encompass the LGBTQ+ community came from a case where a man was fired from his job at a private company for dating another man. Well, he sued, saying it was a violation of the Civil Rights Act of 1964 because it said he was being treated differently just because he was a man. Now, here's the logic the court used to justify this. They said because a business would not fire a woman for dating a man, therefore, firing a man for dating a man was discrimination because the only difference was the gender of the person doing the dating. And therefore, they said that this and sex protection part of the Civil Rights Act of 1964 justifies extra protections for the LGBTQ+ community. All right, let's get into some specifics. What are some civil liberties and civil rights, and what protects them in particular? Let's go over civil liberties first, because I'm going to be going through the Bill of Rights and calling out the different civil liberties that you're going to be responsible for being able to identify, explain, and even identify which amendment protects those civil liberties. You can think of the Bill of Rights as an extension of that foundational idea of a limited government and rule of law. There are basically further limits on what the government is not allowed to do. The First Amendment protects your right to say what you believe. This is known as the First Amendment freedom of speech. The First Amendment also protects your right to print information about the government. This is known as freedom of the press. The First Amendment also protects your right to have whatever religious belief you want. This is from the Establishment Clause of the First Amendment. It also means that the government cannot treat religions differently. A consequence of this is that as some conservative groups are trying to put Christian religion into public schools, the Church of Satan is also demanding they have equal access to be in those same classrooms. Because if you allow the Christian faith to put religious studies into a public school, it would be a violation of the Establishment Clause to deny people who worship at the Church of Satan to have their ideas in schools as well, right? Because the government can't play favorites. That's what the Establishment Clause says. The First Amendment, freedom of religion, also protects your right to practice whatever religion you want. So, for example, this woman who believes that she's a member of the Pastafarian faith was allowed to wear a spaghetti strainer in her driver's license photo because she said that was a core tenet of her religious belief of Pastafarianism. Not going to get too much into what Pastafarianism is, but if you do a quick Google of it, you won't be disappointed. It's pretty entertaining. The point here is that the government can say, well, you can't wear hats and other things in your driver's license photo. However, if it's part of your religion, they can't ban you from wearing it. The First Amendment also stops the government from punishing you for being associated with whatever group you want. This is known as the freedom of assembly. This is why the government cannot ban specific political groups, because you're free to join whatever group you want to help best put forward your ideas and get your ideas passed in government. All right, the First Amendment protects 5 specific civil liberties that we just went over: speech, religion, press, assembly, and petition, which we didn't go over. Moving on to the Second Amendment stops the government from having the ability to ban your possession of weapons. This is why it's so difficult to pass laws or to have laws that address the gun violence problem in the United States. The last time President Trump was president, he worked with Congress to ban what's known as bump stocks. Now, bump stocks are things you can use to turn a semi-automatic rifle into a fully automatic rifle. Those were banned. However, a gun rights group challenged this law, saying it was a violation of their Second Amendment rights to possess weapons, and the Supreme Court sided with the gun rights group, saying, hey, we can't ban bump stocks. Essentially, Americans have a right to have a product that can turn their semi-automatic weapon into a fully automatic weapon. Skipping the Third Amendment, because it's not going to be covered on the test, so we're not talking about it here, is the Fourth Amendment right to not have the government search your property. This means the police can't just burst into your house and look through your stuff whenever they want. They need to get a warrant, they need to get permission, or they need to have probable cause. This gets interesting when we talk about schools because, well, they search your lockers, don't they? Well, those lockers actually don't belong to you. They belong to the school. But what about your backpack? Can they search your backpack? Yes, they can if they have probable cause to suspect that there is evidence of a crime or serious school violation taking place and the evidence is in your backpack. Right? That's probable cause. They have a really good reason to suspect it. But can they pass a random search where they just randomly pick you out of the hallway and say, we're searching your backpack, even if they don't have suspicion that you did something wrong? Well, that's actually up for debate in the courts right now. There's also the question of schools like I used to work in MPS, where they literally did a search of everyone's backpack every single day when they came into the school. Generally, courts will side with the schools in these situations because it's about keeping students safe, and so in those situations, there can be extra limits on your Fourth Amendment protections in order to keep young people like yourself safe. The Fifth Amendment protects your right to not be forced to talk to the government if you don't want to, and you cannot be punished for not talking to the government. This is the famous I plead the Fifth, or your right to remain silent. The reason this was put into place was so that the government couldn't force you to talk and make yourself look guilty even when you're innocent. Right? You can probably, if you use your imagination, think of a situation where you're innocent. You did nothing wrong, but if you're forced to answer questions about what you're doing, it can make you look guilty. And so the government can't force you to make yourself look guilty. A great example of this would be if you're walking home from the movies one day and the police stop and ask you where you're coming from. Well, you didn't do anything wrong. You're just minding your own business. You were at the movies. But if you say, well, I was just at this movie theater and it turns out there's an armed robbery there and the suspect matches your description, well, then they could say, well, look, you match the description of whoever did the robbery, and you just admitted you were at the scene of the robbery. It makes you look pretty guilty, doesn't it? And this is why you don't have to answer questions to the police if you don't want to. The Fifth Amendment also protects your right to not have your property taken away by the government. It also protects your right to not be charged twice for the same crime. You might have heard the phrase, no double jeopardy. That's what this means. This basically means if the government puts you on trial for killing Johnny, and then the jury finds you innocent, they can't just put you back on trial again for the same murder of Johnny because they think a different 12 jurors will convict you. Nope, the government gets one shot at convicting you of the crime, and that's it. Now, if you go on and kill Susie, you can still be put on trial again for the murder of Susie because that's a different crime. The Fifth Amendment also holds the Due Process Clause. This says you have the right to your life, your liberty, and your property, and the government cannot take those away from you without due process. Due process just means the government has to follow very specific steps before they're allowed to punish you. Many of these steps are spelled out in the Sixth Amendment, but some of them are found in the Fifth, like, for instance, no double jeopardy, the right to remain silent. Those are part of due process. The Fourth Amendment is also part of due process. Speaking of the Sixth Amendment goes through a lot more of the details of the civil liberties that you have for due process. So, if they're going to attack your civil liberties, if they're going to try to take your life or your property or your liberty from you, they have to give you a fair trial with an impartial jury to decide your guilt or innocence. The government doesn't get to decide if you broke a law. 12 jurors who have nothing to do with the case, don't know you, don't have anything to gain from the case, don't have anything to lose from the case. These 12 people are picked at random, and their job is to hear the evidence from your defense lawyer, hear your evidence from the government, and then they get to decide whether or not they think you reasonably committed the crime. Again, the term impartial jury just means they're fellow citizens just like you who have no knowledge of or connection to the case. This is to ensure that they're not biased in your favor or biased in the favor of the government, because this isn't about the government punishing you for the sake of punishing you because they don't like you. This is about creating justice for someone who broke the law and the victims who were hurt by your breaking of the law, if you were in fact the person who broke the law. The Sixth Amendment also has another step of the due process, which is the right to question witnesses against you and have witnesses testify on your behalf. If the government says they have someone who saw you commit the crime, you have the right to ask them questions, or better yet, have your lawyer ask them questions to prove that they didn't know what they're talking about or they didn't see you, in order to prove that you in fact are innocent. If you have a witness who said they can testify that you weren't at the scene of the crime, the government has to get that person to show up at court and testify on your behalf that in fact they were with you at that time and therefore could not have committed the crime. Now I know what some of you are thinking. What if someone lies? Well, that's a crime called perjury, and if it's discovered they lied on the witness stand, they can then themselves be put on trial for perjury and be punished with prison time potentially for lying to the jury. However, it has to be proven that it was an intentional lie and not, a honest mistake. Another part of due process is the right to see evidence against you and present your own evidence in your own defense. That is, the government says they have proof you committed a crime. You have the right to have your lawyer examine that evidence to prove that it doesn't show what the government is saying, and you have the right to give your own evidence to show that you indeed are innocent and not guilty. A further due process protection is the right to have a lawyer defend you in court. Again, these are all from the Sixth Amendment. So there are quite a few due process protections found in that Sixth Amendment. If you're trying to figure out, and you will be tested on this on the unit test, if you're trying to remember what civil liberty goes with which amendment, if it's about trial, if you're just guessing, odds are it's probably going to be the Sixth Amendment, right? The Fourth talks about searches. The Fifth says that you can't be tried twice. You don't have to testify if you don't want to. But other than that, all the other criminal protections are found in the Sixth Amendment. So, all right, let's take a break from the Sixth and let's move on to the Seventh. The Seventh Amendment says you have the right to use the courts to sue someone who owes you money because of their negligence, and the right to use the courts to do that, have a jury, if you want, decide whether or not that other person actually owes you money. Suing someone is not about getting rich. It's about making yourself whole again from the damages caused by someone else's negligence. So, for instance, if you hit my car because you're texting and driving, well, I get to sue you for the cost of repairs of my car and any work I lose because of that damage, because it's not fair that I lost out on money because you were doing something you weren't supposed to be doing. That's what a lawsuit is about. If you see lawsuits where someone was awarded multi-millions of dollars, generally that can happen if you lost years and years and years of income because of whatever the negligence of someone, right? That's generally what happens when you get these massive penalties. The Eighth Amendment further limits the powers of the government by saying it cannot punish you in a way that's cruel nor unusual. Of course, that leads to some problems and debates over what is cruel and unusual. Torture, definitely not okay, but death penalty, That's a little bit more questionable. Some people say, yeah, that's cruel and unusual. Others would say no. Are there ways to execute someone that's not cruel and not unusual? Who's to say? Well, the courts. The courts are to say, actually. Okay, that's a whole lot of civil liberties. Let's switch gears here and talk about some of the civil rights that are protected by the government. Again, civil liberties are things that you just have because you're human. The government doesn't give you them, and the Bill of Rights are just further protecting them by once again saying, no, the government cannot do these things. It is limited in its power, especially around these civil liberties. Civil rights are extra protections granted to people by the government because they belong to a group that has been historically discriminated against by the government. The 15th Amendment says you cannot be denied the right to vote based on your race. The 19th Amendment says you can't be denied the right to vote based on your gender. And as you'll remember, you can't be denied housing or employment based on your race, gender, or sexual orientation because of the Civil Rights Act of 1964, which was passed by using the Equal Protection Clause of the 14th Amendment. Are there any limits to our civil liberties and civil rights? Yes, absolutely. Nothing is unlimited. There are no unlimited rights and there are no unlimited protections. For example, freedom of speech. You can say what you want, but you can't encourage violence in front of an angry crowd ready to do that violence. The Fourth Amendment clearly states the government cannot unreasonably search you or your property. However, they can search you if they have a reasonable reason to believe you've committed a crime, such as they just saw you do it. They can also search you if you're under arrest to make sure that you don't have anything on them that could hurt the officers. And if you're under arrest, they can search anything in the immediate area around you that is under your control to make sure that you didn't try to hide or destroy any evidence that could be used to convict you. They can also search you if you're acting suspicious in certain areas. You might be thinking, who gets to decide what is suspicious? You might be thinking, who gets to decide what areas are protected? As far as the areas that have extra levels of protection, that's decided by our legislative branch. And as far as whether or not you're acting suspicious, well, that's determined by the officer at the time, but they do have to prove in court they had a very good reason to suspect you of doing something illegal. So there are some fail-safes here, right? They have to prove in court that they had a really, really good reason for violating your Fourth Amendment rights. The Second Amendment clearly says you have right to bear arms, but there are limits. You can't have nuclear weapons, for instance. The Eighth Amendment clearly says that there can be no cruel and unusual punishments, but how do you define cruel and unusual? Is this news article here cruel and unusual? It says here, a man in Ohio was convicted of soliciting a prostitute, and the judge sentenced him to wearing a chicken suit and holding up this sign in a well-traveled area. Is this punishment cruel and unusual? And if you've been paying attention to the news lately, over the last few years, the courts have been moving to being more willing to allow discrimination against the LGBTQ community if not discriminating violates your religious belief. This year is referencing a Supreme Court case where a website designer did not want to design a website for a gay marriage. The court said that she did not have to provide them services and that she could not be punished for discrimination because her religious beliefs said that it was wrong for a gay couple to get married, and therefore she did not have to follow the anti-discrimination laws in the state of Colorado, which said if you're a business open to the public, you must accept all business and you cannot discriminate based on sexual orientation, race, or things like that. All right, well, there you go. Take a few minutes here, briefly rewrite today's goal from the top of the worksheet or the front of the notes. Then identify 3 important facts from these notes that help you understand that goal. And finally, write out one question you still have about this topic that can help you better meet this learning goal. All right, I'll see you in class.